or bar an undocumented client from regularizing their status, their legal status. This could mean, for example, pleading to a related offense, advocating for a different sentence, pushing for a pre-plea alternative to incarceration program, or allocuting to certain facts and not others. If you have negotiated a safe plea and your jurisdiction permits a plea agreement to be binding for a certain sentence upon the court, then negotiate for such pleas. A binding plea can ensure that the court doesn't impose a different sentence with potentially damaging immigration consequences, and you can be more certain of the possible immigration consequences stemming from that plea. Again, all of this depends on the client's immigration status, priors, and other facts that you've gathered during step 1. Defense counsel can often craft plea agreements that avoid adverse immigration consequences or that leave the non-citizen with relief available in immigration court, and should do so if important to the client. If you can't do so, discuss the pros and cons of taking the case to trial with your client. For many immigrants, deportation is far more severe than any other penalty, and they will do whatever it takes to protect their right to remain with their families. We want to give you a few key concepts that form the foundation of criminal immigration law, or crimmigration as it's known. First, immigration status. As we discussed in the previous section, immigration consequences depend on a number of facts, including immigration status. Whether a person can be deported or on what grounds flows directly from immigration status. The main categories of immigration status are lawful permanent residents, that means people with green cards, asylees and refugees, and undocumented immigrants. This includes people who have lost their status or never had legal status to begin with.
So why is immigration status so important? It's important because the immigration removal categories that apply to an immigrant flow directly from the immigration status that Gwen just talked about. And the linchpin of these removal or deportation categories are the concepts of inadmissibility and deportability. An inadmissible offense is one that will prevent an undocumented person, asylee, refugee, or other non-citizen from getting lawful permanent residency. It'll also prevent a green card holder from returning to the U.S. after a trip abroad. The main inadmissible categories include drug offenses, reason to believe a person is a drug trafficker, a crime involving moral turpitude, prostitution, and commercialized vice. A deportable offense is one that can get a person who already has lawful status here, like a lawful permanent resident, kicked out of the U.S. And deportable offenses include drug offenses, and here there's actually an exception for first-time simple possession for personal use of 30 grams or less of marijuana. Also, a crime involving moral turpitude, depending on when and how many, a crime of domestic violence, stalking, or certain crimes against a child, a criminal or civil finding of a violation of certain parts of a protection order, a firearms offense, or any aggravated felony. And in immigration, we should mention that the aggravated felony term includes a number of different offenses, including low-level violations or misdemeanors. Now, we haven't covered all of the possible offenses or their exceptions, but we have given you the basics. You cannot tell just from the name of your criminal statute whether it fits within the categories I just discussed. You must read the statutes in case law, and as we'll discuss later, there are many practice guides to help you.
And finally, we want to touch briefly on one more substantive area of immigration law. What constitutes a conviction for immigration purposes? As we've mentioned, some grounds of removal are triggered by a conviction. But a conviction under immigration law can be applied to some dispositions that the convicting jurisdiction doesn't consider a conviction. A conviction can include Alford and no contest pleas, post-plea diversion programs resulting in the vacatur of the plea, and other dispositions resulting in vacatures after rehabilitation or drug treatment. Further, guilty pleas and pleas of no contest will result in a conviction for immigration purposes, regardless of whether a sentence of incarceration was imposed or suspended.
Now let's give you some examples. Take the case of a lawful permanent resident who is facing a charge of distributing a small amount of cocaine. Cocaine distribution is both a controlled substance offense and an aggravated felony. So you'll advise your client that pleading guilty to this offense will make him deportable, ineligible for relief from deportation, permanently ineligible for naturalization or citizenship, subject to inadmissibility when returning from a trip abroad, and subject to mandatory immigration detention.
Now, let's say that you got a plea to simple cocaine possession for this client. You'd advise this client that this conviction would still be a controlled substance offense and make him deportable. And there would also follow the accompanying naturalization, detention, and traveling issues in immigration court. If this client had no priors and had his green card for a certain amount of time, he could then apply for relief from deportation, which would allow an immigration judge to consider his equities. And you would advise the client of this as well. We want to touch on a couple of other issues that relate to your representation of a non-citizen client. First, from the outset of your representation of the client, strive to obtain release for your client during the criminal case. Detention can often result in an ICE detainer being lodged against the client while in custody and can result in mandatory detention during the immigration case. At any bond hearing, highlight two main points for bail, or two main factors for bail: danger and risk of flight. Highlight ties to the community, permanent employment, family ties, and long-term residence in the area. Remember, immigration status can sometimes reduce the risk of flight. Not showing up for their case can adversely affect their immigration cases, and bail jumping itself can be a deportable offense.
Now, a word about judicial advisals or prosecution requests to include information about deportability in plea forms. Remember first that courts and prosecutors do not have enough information to give your clients the specific individualized advice based on their facts that Padilla requires. They most likely don't know whether your client has priors, whether he's married to a U.S. citizen or takes care of a disabled citizen parent, or whether he's been in the U.S. for 30 years, all of which might be relevant. So judicial advisal does not take away your duty to investigate and advise your client. Second, be aware that general advisals, even well-intentioned ones, such as this plea may result in your deportation, are not always accurate, or may confuse a client for whom you've just negotiated a plea that will absolutely not result in deportation. Be prepared to discuss these issues that may come up with your client.
Law enforcement agencies in some jurisdictions collaborate with ICE. In some jurisdictions, people are asked for birth or citizenship information at the time of their arrest or in some other place in the process. This information can also often be transmitted to ICE and can result in immigration detainers being lodged. Thus, you may want to advise your clients that they should refrain from revealing citizenship, country of origin, or immigration status to law enforcement. Remember that asking immigration status implicates Fifth Amendment rights because alienage, as it is called, is an element of several federal offenses. The Public Defender Service of the District of Columbia has developed a red flag document to help attorneys practicing in the District of Columbia to identify immigration issues in criminal cases. It's a 2-page document entitled the PDS Quick Reference Guide. It contains tips for best practices with plea negotiations, advice on judicial advisements, sentencing, common formal and informal agreements in criminal court that can affect a client's immigration status, and special considerations for certain classes of non-citizens. And the information on types of criminal offenses that constitute deportable offenses in immigration court for the District of Columbia. This document is posted on the DC Public Defender Services website and is now available on the ABA website as well. In an effort to comply with new requirements under Padilla, each public defender office can develop its own red flag document, or cheat sheet if you will, to assist public defenders in readily identifying immigration issues that arise in criminal cases in its respective jurisdiction. It's also a good idea to create a criminal defense practice group in your public defender's office to develop a pool of expertise in immigration, or crimmigration as it's known, which is the intersection between immigration and criminal justice.
We've given you a lot to absorb. We've talked about defense counsel's responsibilities under Padilla v. Kentucky, given you an overview of immigration consequences of criminal dispositions, and discussed the key concepts that will form the foundation for your learning this area of law. The good news is that there are a lot of resources available to defense attorneys to help in determining immigration consequences of clients' criminal cases and pleas. Many of these resources are available online and free of charge, and we will highlight just a few of these. The Defending Immigrants Partnership has been training defenders on the immigration consequences of conviction since 2002, and the Defending Immigrants Partnership, or DIP, partners have been doing so since the 1980s. DIP's website contains a wealth of free materials to educate you on this area of law and to help you properly advise your client, including national training materials and a national manual, practice advisories, and state-specific resources. We recommend that every defense attorney register for this site. It's free and it's indispensable. DIP partners, the Immigrant Defense Project, Immigrant Legal Resource Center, and National Immigration Project of the National Lawyers Guild also have resources on their individual websites. And IDP's hotline, 212-725-6422, also provides free case consultations to defense attorneys in any state. As the Supreme Court clarified, it's the criminal defense attorney's duty, your duty, to educate yourself on the immigration consequences of criminal convictions so that you can properly advise your client. Like other criminal defense issues, you can learn the law yourself, or you can consult with experts. In the end, however, the duty is yours. And now, McGregor will talk to you about how that duty extends to penalties other than immigration that are enmeshed with criminal charges and dispositions.
Thanks, Benita. One of the most exciting aspects of the Supreme Court's decision was its explicit recognition that as a result of their involvement in the criminal justice system, our clients suffered devastating consequences that extend well beyond the courthouse walls. In many ways, the court broke surprising ground by acknowledging Mr. Padilla as a real person, not just a defendant, a step that all players in the criminal justice system must now take. From the moment of arrest, our clients are in danger of losing hard-earned jobs, stable housing, basic public benefits, and even their right to live in this country. And it's not just clients who suffer. Whole families bear the consequences. For many clients, their children, and their families, these consequences are much more severe than any criminal penalty. So what does this mean for daily practice in criminal courts? At the Bronx Defenders, we've worked for the past 10 years to catalog these so-called collateral consequences with a focus on how defenders can not only advise clients, but actually use these consequences as advocacy tools. You can now leverage Padilla to apply these proven strategies that will help your clients and get better results in your criminal case. So how can we use collateral consequences as an advocacy tool? First, we have to learn the range of penalties, like deportation, that are the predictable results of criminal proceedings. Now, these penalties will vary by jurisdiction and by client, but the obvious ones include eligibility, including lifetime bans for publicly subsidized housing, employment licensing and military service, student loans, government benefits, sex offense registration, voting, and firearms. Now, these penalties share with deportation the same unique characteristics that were outlined by the Supreme Court. Legislatures around the country have intimately related the availability of these programs or rights to criminal charges and convictions. Legal changes over the last few decades have made termination or rejection from these programs or rights nearly an automatic result for a broad class of clients. The steady accumulation of these penalties and their potentially disastrous effects on clients and their families have dramatically raised the stakes of any arrest. Some of the most draconian consequences result from misdemeanors and petty offenses. Take these examples from New York. A plea to disorderly conduct, defined by New York law as a non-criminal offense, makes a person presumptively ineligible for New York City public housing for 3 years. To give you some context, there were over 44,000 pleas to disorderly conduct in New York City alone last year. 2 convictions for turnstile jumping make a lawful permanent resident non-citizen deportable. A conviction for any crime in New York bars a person from being a barber, a boxer, or a bingo operator. And simple possession of a marijuana cigarette cuts off federal student loans for a year. In a few minutes, I'll outline a rich set